Good morning, everyone. My name is Catherine Marshall.
And I'm Mackenzie Irwin.
And we're lawyers at McDonald & Associates. And thank you so much for tuning in today. This is our monthly webinar, which we feature at the last Wednesday of each month. And today we're talking about a very interesting subject, dependent contractors and the shifting and evolving workforce that we're living in right now. So just to give you a bit of context, it used to be that there were only two categories of workers. There were employees and then there were independent contractors. And this binary was pretty common. It used to be that people would stay at the same jobs for 30 years. They wouldn't move around. It was really obvious when someone was an employee. But now as the workforce is evolving and we have technology, we have a growing workforce that works remotely. People don't need to be housed in bricks and mortar buildings doing office work. We're seeing a lot of fluidity in work relationships. And there's this emerging third category of workers called a dependent contractor, where they're not quite an employee, but they're not quite an independent contractor. They fall in that milieu. And that milieu of worker is only going to increase in numbers as our workforce evolves, as we see companies like Uber, we see tech companies rising, we see a lot of big companies actually closing offices and having their workforces work from home, using their own tools, their own laptops. The millennial population is going to be more attracted to this kind of work relationship. And it's had a really interesting impact on employment law and case law, because this is a new concept that our courts and our governments have had to deal with over time. So we're going to talk about what exactly is a dependent contractor, what you have to think about as an employer in ensuring that you're protected and that you're ensuring that everything's clear about what the work relationship is, and how the law is actually granting employment rights for the first time to this new class of workers, and what that means for you as an employer.
Yeah, so I thought we'd start out by doing a little bit of an overview of what the difference is between an employee, an independent contractor, and a dependent contractor. So employees are afforded certain rights under the Employment Standards Act, such as minimum wage, public holidays, vacations with pay. In addition, these employees are afforded certain common law rights, such as reasonable notice. One may be considered an employee when the business provides you with the tools, your equipment, or any materials to perform your job. Your pay isn't affected by the way in which you do your work. So, for example, if you work faster or create a better product, you're not necessarily going to be paid more. And more importantly, the business decides what you do, how much you'll be paid for it, when the work needs to be completed by, and how and where you complete your work. Now, contrary to an employee, the independent contractors are not afforded the same protections under the Employment Standards Act. There's no applicable legislation relating to the termination rights of an independent contractor. All of this will be set out in your independent contractor agreement. One may be considered an independent contractor when, for instance, you own and you're responsible for all of the tools or equipment that you use to do your job. If you're in the business for yourself and you make a profit and have a risk of losing money for the work that you do, you might be considered an independent contractor. And when you determine how and when and where your work is completed. In addition, the business that can end your contract for services depending on what's written in your independent contractor agreement.
And an example, like a clear example of an independent contractor might be, for example, a freelance writer, right. Someone who works writing pieces for different newspapers, but They have a bunch of different gigs and they do their work at home. They don't come into the office. They use their own laptop,
Right.
And they submit work as they feel fit to do it. So I mean, they might have an agreement saying like give us a column every 2 weeks or something, but they write for a whole bunch of different places.
Right.
And that's a very clear independent contractor type relationship, and it would be very clear in the contract too that that is what that relationship is.
Exactly. So then we were just talking about the new emerging category of worker. This is called the dependent contractor. So workers can be either employees or contractors, as we've discussed, but when the courts find someone to be a contractor, they'll go on to decide whether that contractor is a dependent contractor or an independent contractor. Dependent contractors are not employees, but they're somewhere in the middle. And due to their economic dependence and the exclusivity of their work with a certain employer, they're entitled to reasonable notice upon termination. So economic dependence and exclusivity refers to how much the contractor relies on a certain business to provide them with work. For instance, if a contractor gets all of their work from one particular employer and works only for that one business, the courts will find that the contractor is economically dependent on that business and will have a high degree of exclusivity, meaning that the courts will likely find them to be a dependent contractor. And a number of courts in all jurisdictions in Canada have since found dependent contractors in certain employment or working relationships. Some examples include self-employed truckers, commissioned salespersons, long-term contractors, and even real estate agents. More recently, doctors had been found to be dependent contractors in the Beatty decision.
And I'll talk about that a little bit. So this is a really important legal development because for a long time, there's certain classes of workers that everybody assumes are independent contractors because that's what they've always been thought of as. And that's, maybe the label that they've been given by their employer or by the government. But what the courts have done is they've actually said, we don't really necessarily care about how you're labeling this employee or this person, whether you're calling them an independent contractor or an employee. Let me look at the dynamics of the relationship to see, is this person really an independent contractor or are they actually something a little bit more? And why that matters to you as an employer is just because you label someone as an independent contractor in an employment contract doesn't necessarily mean that that is how the courts are going to see it. Should that person be terminated and they go and hire a lawyer, the lawyer might argue, look, this person is actually a dependent contractor and they're entitled to reasonable notice period and all these things. So it's really important to actually look at the work relationship and ask yourself, is this person truly an independent contractor or are they something a little more? And for the first time in Canada, doctors in certain situations have been deemed to be dependent contractors. And in 2018, Natalie McDonald, the principal of this firm, she brought a case to trial, which is Beatty versus Women College Hospital, which she brought it in 2017 to trial. And a decision was rendered in 2018 where the courts found for the first time that the doctors in this case, the plaintiff doctors, were dependent contractors, not independent contractors. And the reason why that's significant is doctors are just, they're one of many categories of workers that people just assume and treat as independent contractors. But, in this particular case, these doctors had worked for the same hospital for many, many years. They, came to work every day. They relied exclusively on the hospital for work. And there was a high degree of reliability and economic dependency and exclusivity that these doctors had on the hospital. And when that hospital closed due to budget cuts, they didn't have work anymore. And the courts found that these particular doctors were entitled to a very lengthy reasonable notice period because they were actually dependent contractors. They weren't independent contractors, as was assumed, the relationship that is the sort of the going assumption that people that the courts and the government have when it comes to doctors and their relationships in our healthcare system to hospitals and so forth, because they bill OHIP, and that's just kind of how it works. So that's significant. And what the courts looked at in that case was they went through this whole test about looking at, well, what is the relationship? Have these people been working there, the same place for many years? Are they, is there a high level of economic dependency? Do they rely on the hospital to provide them with the tools for their work? These were all things that they went through in the court system in that test, and this is significant. Now, one of, while Natalie was successful in having the courts make this determination, there's a piece of legislation in the Public Hospitals Act that basically says that if the hospital is closed for budget cuts, then doctors can't actually sue for reasonable notice period damages. And that's because, the going assumption when this legislation was brought in was that doctors were always going to be independent contractors, and there could never be a situation where they could be anything else, because the whole legal construct of dependent contractor wasn't actually recognized by the courts yet. So this case is actually a case that our office has commenced leave to appeal to the Supreme Court of Canada on, to have the Supreme Court rule for the first time in a very significant way, what is the construct of a dependent contractor. So that's an example, and we're gonna be seeing more cases like that. And actually there's a few big cases working their way through the court system right now that deal with the issue. So Mac, why don't you go into that?
Right, so we've highlighted a few cases to watch. The first one being this Uber case. In that case, drivers for Uber have brought a class action against Uber, claiming that they're employees and not independent contractors. And therefore, that would entitle them to minimum entitlements under the Employment Standards Act, such as minimum wage, things of that sort. So this case will definitely change the field on independent contractors. It's a huge decision that will be coming up. However, in my personal opinion, the drivers will have a tough claim to establish that they are employees. And that's for a few reasons, mostly because they provide their own cars. So they provide their own tools, they use their own vehicles when working for Uber. An Uber driver decides when and how much they want to work. That's completely up to them. They turn on their app when they want to work, and they sign off whenever they want. Uber has no control over when, or doesn't dictate when or how they work. And in addition, their pay is directly affected by how much and how fast they work. So that's something that would indicate that they would be an independent contractor and that they would not be an employee. Now, perhaps they could argue that they could be found to be a dependent contractor. However, I also think that this might be a tough sell, mostly because Uber drivers, they can work for multiple companies. There are different rideshare programs out there. Uber has no control over who they end up working for. I was gonna say, like, there's no exclusivity. I mean, I think we've all been in Uber cars before where we've seen the driver has the Lyft app open and the Uber app open, and they're switching between depending on which one has better rates at the time. Exactly.
So I think Uber's actually been very careful in constructing things in a way that it's very clear that people who drive for Uber are independent contractors, and it would be a big uphill battle to argue that they're something else.
Yeah,
but people are trying.
Exactly. Yeah, so we'll have to wait and see. That will be definitely a case to watch going forward. The second case that we highlighted was the Deloitte case. So this is another class action. It's against Deloitte seeking damages on behalf of lawyers who worked for the accounting firm's document review branch. These lawyers were classified as independent contractors, which allowed Deloitte actually to deprive them of certain vacation pay and overtime pay. It also gave them the ability to fire these lawyers at will. So once a document review project ended and they no longer needed their services, they just stopped. So the courts, basically, these lawyers, in addition, these lawyers were not permitted to work from home. They had to come into the Deloitte offices every day. They had to use the Deloitte computers. They weren't allowed to use their own laptops to do the document review. And they weren't permitted to negotiate their own wages. So these are some things that kind of indicate that they could be found to be employees. So this would be another important case to watch.
Yeah, and I would say like that case, unlike the Uber case, I think there's a lot of gray zones there where it's very, very possible the courts could find that actually, despite the fact that Deloitte was labeling these people as independent contractors, for all intents and purposes, they weren't. They were essentially employees.
There's a strong argument for them to be found as employees.
Now, and I think, Mac, we were talking earlier before this webinar about, there are some things that employers can do to make it clear that someone is in fact an independent contractor, not something else. And what are some of those things?
Yeah, so basically we were discussing that it has to be clear the relationship between an independent contractor and the company they must make sure that that independent contractor is getting work from other sources, that they're not the sole and exclusive source of all the work that the independent contractor gets. In terms of advice, we're warning employers beware. Don't slap the label of independent contractor on a working relationship that is more akin to an employer-employee relationship.
And you can, if someone, you're hiring someone as an independent contractor, make sure that you're making it abundantly clear in the employment contract that this is what this person is, that they are an independent contractor. You can have provisions in there that say that they can work for other sources. Make it clear that who is providing the tools for their work. You got to make all those terms really clear. The courts have very much caught on to the fact that there are some employers out there who just slap the independent contractor label on as a way of avoiding paying out reasonable notice period, providing benefits, and that sort of thing. And the governments, the various provincial legislatures have also caught on to this. And they recognize that this milieu of people who don't quite fall in, as employees, they're not quite independent contractors. They recognize that these people might need a bit more protections and transparency and certainty in the law. And they've started to do things that we all have to pay attention to as people who follow employment law. The Kathleen Wynne government, shortly before they lost, the Liberal government in Ontario was actually considering adding a provision in the Employment Standards Act that essentially would have said that the onus was on the employer to prove that somebody was in fact an independent contractor, that the assumption would be that they were an employee. And if you're calling someone an independent contractor, you have to actually prove it. Now, they ended up not going that far, and they ended up, not actually doing that. But that just shows you that
it's top of mind.
It's top of mind, and this is kind of where things are headed.
Yeah, their courts are increasingly turning their minds to this misclassification, and the new category of dependent contractor is coming up more and more in recent decisions. So.
Exactly, and we're only going to see more of it with the younger work population, more app-centered, companies like Uber, ride sharing. There's so many of them now. This is basically the future of our workplace. It's not our father's, grandfather's workplace anymore. So that's probably all the time we have today. If you have any questions, you can
feel free to email them to socialmedia@mcdonaldassociates.ca.
Yes.
And we'll address those questions as they come in.
Yes, and if you have an idea for a topic you want us to cover in the webinar, you can also send an email to that email address and let us know, and we can consider covering it in next month's webinar.
Yeah.
So thank you so much for tuning in, guys, and hopefully you learned something and we were helpful today.
See you next
month.
Wednesday of the month.
Yes. Bye.
Bye-bye.